What is the Medicaid gifting penalty and how does it work?
The gifting penalty is a concept that comes out of the eligibility for medical assistance or Medicaid. We call it medical assistance here in Wisconsin. And in order to understand that, let me back up a little bit and start at the beginning. Usually when we're dealing with these issues, we have to make sure that our clients meet the asset requirements. And there are very strict asset requirements if you're going to qualify for medical assistance. If you're a husband and wife, for example, there are different levels that we would be looking at. If you have countable assets are all the assets that aren't exempt. We know that a house is exempt, a car is exempt, household goods and furnishings are exempt. But if you have checking accounts or savings accounts, stocks, bonds, annuities, life insurance, a cabin up north, the hunting 40 up north, if you have those kind of things, those are all countable assets. And if those countable assets are $50,000 or less, then the community spouse is entitled to keep the entire amount. If those countable assets are more than $50,000 but less than about 120,000, I'm rounding here, but about 120,000, then the community spouse can keep half of those assets. If the countable assets are more than 120 but less than, again I'm rounding here, but about 240,000, then the community spouse, the maximum that the community spouse can keep is $120,000. Okay, so that sets up the question, well, what if my assets are more than 50,000 or more than 240,000, as the case may be? And so then we would say, well, then in order to qualify, we have to give away some of those assets. Therein comes the penalty, the gifting penalty. Social Services' position on that is, if you give away assets, that's okay, but you can't give away all of your assets and then the next day come to us and say, well, I don't have any assets, I can't pay for my care, and so I need some assistance from you. They will not tolerate that. So we have to discuss with our clients the gifting penalty. This is the way it works. If you make a gift, then, and if the gift has been made in less than 5 years from when you are making that request from the county for some assistance, then there will be a penalty period calculated. The penalty period is calculated by taking the amount of the gift and then dividing that by the average cost of nursing home care here in Wisconsin for 1 month. You can calculate it by day, but most of our clients understand it better by month. So, for example, if we have a cost of care, average cost of care, which the state tells us these days is about $7,500 a month. If we have an average cost of care of $7,500 a month and we make a gift of, say, $15,000, we divide the $15,000 by the $7,500 and we come up with 2 months. What that means, that's the penalty period. So what that means is that, yes, you can make a gift of $15,000, but you will have to pay for your own cost of care for the first 2 months after you make the application for assistance. If, and this gets back to an earlier comment I made, if you get to the point where the gift has been made more than 5 years ago, then there is no issue, the penalty period doesn't apply. Otherwise, the penalty period, again, is a mathematical formula. You divide the amount of gift by what the average cost of care is, and that tells you how long you will have to self-pay for your cost of care.